Good morning, friends. Yesterday I told you regarding section 35A of the CPC. 35 deals with imposing of the cost. You may be knowing the cost may be imposed on the plaintiff, maybe on the defendant, if they fail to produce the witnesses, if they fail to produce the documents, or if they fail to take the further step. Definitely the court can impose costs. And even at the time of judgment also, they can impose costs on the maybe on the judgment debtor regarding the expenses met with by the plaintiff. And section 35A, it is an amendment, so it clearly says that if any vexatious or false claims or false petitions are made, definitely the court can impose compensatory costs. So in order to compensate because of the vexatious claim, normally the other person will suffer like anything. So definitely, as per the law of torts or as per the basic principles of the CPC, the concept ubi jus abi remedium. That means for every wrong there is a part of compensation. Like that they can impose costs. So why I am telling is this has come to the notice, it has happened right in front of the Supreme Court itself on Tuesday, that is just day before yesterday, when the Honorable Chief Justice of India was hearing a petition. Actually, this petition is against a High Court judge of Bombay, a former High Court judge of Bombay. That means a retired High Court judge of Bombay. So the woman advocate, the counsel, argued that the judge, retired High Court judge, appeared before the trial court in this manner. Actually, we may be knowing, once the High Court judge or the Supreme Court judge retires, then he cannot appear in any court, because it was the post of the High Court judge or Supreme Court judge was a gubernatorial position, and once they appear before the court, they may influence the judges present there, because they might have worked under them, or they might have been under the impression that this man, having retired as High Court judge, means he has got enormous knowledge. Likewise, definitely the influence will be there. So in order to avoid, already the Constitution says that once you retire as a Supreme Court judge or High Court judge, you cannot practice in the local courts. Then CJ, oh really, it's unfortunate. How can a High Court judge appear before the trial court? Come on, you show me. He has asked the counsel, you show me the evidence. Then we will definitely impose costs on him, if not on you. Then the counsel said that basing on the chamber practice, that is actually entire thing was drafted, entire arguments were prepared by the judge, but another lawyer came and argued the same matter before the court. It is nothing but chamber practice. We can't. So the Honorable Supreme Court CJI stated that don't you know the difference between the chamber practice and also the practice of appearing before court? Chamber practice anybody can do after retirement. Instead of sitting inside, he can go to chamber, he can start an office and he can guide them, no problem, because his actually the practice should be utilized for the common good. I mean, he got so much of enormous experience in the field of law. Definitely, I retired High Court judge can start a chamber, can send his juniors. There is no problem. But if he personally appears, definitely it is deprecated, not allowed. So yeah, the counsel agreed that the former High Court judge has only written the arguments, and in his place or through him some other advocate represented the matter in the trial court. It's not a problem. So now the Honorable Supreme Court CJI has come down heavily on the advocate. See how much cost we have to impose on you. Definitely we have to impose, even though section 35 of the CPC says that the cost should not exceed 5,000 rupees, or in case of small causes court, it should not exceed 250 rupees. But Supreme Court has got inherent powers. How much cost? Then the counsel normally argued and requested the Honorable Court, Your Honor, after all, this is a matter of legal aid. The person had no advocate. I have come as a legal aid. So please excuse me. Then the matter has been. So he has withdrawn the petition, and without cost, the SLP was dismissed. So please remember. So this is the effect of imposing the costs. You must be very, very careful. So whenever, if you want to level certain irrigations, you must be doubly sure that too before the judges. So it's not a small game. So alleging and once again retrieving back, it's not correct. But please remember section 35A. Don't forget, costs can be imposed for false and frivolous claims if proved. This is what I want to tell you. So thank you very much.